Hello and Namaste. I am Ketan Kank from 19.2 Consulting. In today's video, we are going to discuss about the deletion of the name of the shareholders from the records of the company. Many a times it happens that investments are made in joint names. So a person makes an investment along with his spouse and children, along with any of the other family members or associates. There are multiple benefits of making investments in joint name. One of the primary benefit is that after the expiry of that person, if that particular share or stock or security or investment has been held in joint name along with some other person, then it is not treated as transmission case. Additionally, the value of the securities is more than 5 lakh rupees, then it will also attract, or transmission cases will attract the obtaining of the succession certificate. But since the shares are held in the joint name, the companies or the RTAs treat it as not as a transmission case but as the original investor case, because technically one of the legal heirs or one of the joint holders of those shares are alive. Now, suppose if a particular share is being held by person A along with person B, and if person A deceases, if he expires, then person B can claim the shares in his or her name as the joint holder. In that case, the joint holder or the legal heirs don't have to go to the court and obtain legal heirship or a succession certificate, and it will not be treated as transmission case. Second holder will become the primary holder of the share. But on the contrary, the second holder deceases before the first holder, then there would be no question again of going to the court, because first holder will have all the primary rights in the sole manner. But we are talking about the matters relating of the deletion of the name. Even though the person is not required to go to the court and obtain the succession certificate and the transmission procedure to be followed in case of where the investors has been deceased, despite of that, there is one procedure of deletion of name that has to be followed by the joint holder. Unless and until the name of the person or the holder who has deceased is not deleted from the company's record, the company will keep looking to it as a joint holding. What a person has to do to delete the name, the person has to simply write it to the RTA and furnish the death certificate of the shareholder or the joint holder who has deceased. The company or the RTA will issue a name deletion form to the existing alive holder. The existing alive holder will have to fill in that form. Then that person has to, if the shares are being held in the physical format along with the original share certificate, the person has to send that form along with his own KYC and the death certificate of the deceased holder. Once all these documents reach to the company will update the details on its records. It is imperative that the investors should know that in case the joint holder is deceased, then the name deletion form has to be issued, or that person has to write to the RTA. The RTA will issue the name deletion form, and the name deletion form along with the supporting documents has to be submitted back to the RTA. And if the person is holding the original physical share certificates, the original physical share certificate will also have to be submitted to the company. The company will not issue renewed or duplicate share certificates, but the company will get the shares dematerialized and then update its records only with the existing alive holders of the shares. This is exactly how the deletion of name on the securities takes place. Should you have any query relating to the deletion of the name on the securities and reclaiming of the shares, you may feel free to call or reach out to us. You may reach out to us by marking your comments in the comment section of this video, or you may also write to us on info@19.2.in. Till the time, this is Ketan Kank signing off. Thank you so much.